Yeah, good afternoon, dear audience. I started my university career a long time ago as a lecturer in family law at the University of Iceland, and later on I became a judge to the European Court of Human Rights in respect of Iceland. And after that I became a domestic judge on the appeal level. So I have approached these family law issues from different angles, and this is the experience that I draw upon when addressing you on this issue of shared parenting under the European Convention on Human Rights, and as it appears in the case law of the European Court of Human Rights. Shared parenting is an arrangement in which both parents actively participate in their child's upbringing following a separation or a divorce, or even in a situation where they have never lived together. This arrangement has gained increasing recognition in international family law as well as on the domestic front. In the following, I will say a few words about shared parenting from the perspective of the European Convention on Human Rights, or the Convention as I will address it. The Convention does not explicitly recognize or provide for shared parenting as a right for the parents or the child under the Convention. However, several of its provisions are relevant for the protection of parent-child relationships and the interest of children that may have relevance for the discussion on shared parenting. Now, what is shared parenting from the point of view of, let's say, the Convention? Shared parenting refers to a legal custody of a child being shared between parents that do not live together, or even when they have never lived together. In this regards, it refers to joint legal custody as a form of shared parenting and based on an agreement between the parents, or based upon a decision by the authorities or the courts regarding the custody of a child. Physical custody pertains to the child's real living arrangement and relations to both parents. Shared parenting in substance does not necessarily imply equal time, but meaningful involvement of both parents. Now, across Europe, there is no uniform legal definition or standard for shared parenting. Some countries support joint legal custody as a default legal arrangement, like, for example, here in Iceland. And my understanding, and this is also relevant for Sweden and Belgium, others still rely on sole custody models unless both parents agree otherwise. Now, the court in Strasbourg is more concerned with securing mutual contacts and visiting rights between the parent not having legal custody and the child. Differences in legal framework, whether it be in joint custody or sole custody, potentially raises important questions about compliance with convention standards, because in both systems, difficulties with enforcing real visiting contact rights are persistent. Leaving aside the legal concept, shared parenting is wider in a sense that it describes a situation where a child has in reality two involved parents. It is free to access both parents as a matter of routine without exact time measurement. Parents both have a moral authority. Both parents are involved in all aspects of the child's life, daily life. In the best possible world, this can potentially all be achieved without joint custody in the legal sense of the word. At the outset, it is important to note that in cases relating to family relations, joint custody, etc., the court leaves a relatively wide margin of appreciation to the states in deciding how to approach this. This is reflected in the case law of the court, showing that joint legal custody of children by parents not living together is not a legal right under the convention. However, the case law shows that the court attaches great importance to the right of a child to have contacts with both parents, as well as the right of parent not having custody to have contacts with the child. Despite shared parenting not being a right as such under the convention, it is clear from the case law that it attaches importance to the right of parent not having custody and not living with the child to be in firm, regular contact with the child, and if not, this can run counter to the child's interests. Obviously, those factors that determine if there is in reality a shared parenting are not easily translated into a direct enforceable right. The court's philosophy on this issue is more expressed through the cases dealing with visiting and contact rights. The cases are therefore about actual togetherness, so to speak, where the very existence of a legal right is not in itself enough for state to escape responsibility under the convention if it is not enforced. The precondition for shared parenting is both parents' involvement in the daily life of the child. Maybe we should talk about parental cooperation. I suggest that as a useful wording in this context. Here are the most relevant provisions of the convention when it comes to shared parenting. First, we mention Article 8 of the convention, which is about the right to privacy and family life and family relations, which is an important aspect of the interpretation and the way in which the court in Strasbourg has understood Article 8. And then we have Article 14 on prohibition against discrimination, and we see problems being dealt with in the case law of the court where in particular fathers that do not live with their children or their mother, even those who have never lived with a mother, they are repeatedly being victims of discrimination, where fathers and mothers are treated differently by law and in practice. And then we have Article 6 of the Convention, which deals with fair trial. And this is, of course, connected to sort of things that relate to difficulties in enforcing decisions of authorities or courts and so on and so forth. The first paragraph, everyone has the right to respect for their private life and family life, their home and their correspondence. And this concept of family life is what is most relevant in cases relating to child and parent relationship. Paragraph 2 of Article 8 provides for justifiable limitations on the rights provided for in the first paragraph. And in short, these limitations must be in accordance with law, namely the domestic law, and they must be seen as necessary in a democratic society. And then there are further details what this means, but I'm not going to read them out here. This provision safeguards the relationship between parents and children and underlines the importance of the child's best interest. The court, via interpretation, has clarified Article 8 in such a way that it encompasses the relationship between children and both biological and social parents. It has repeatedly affirmed that the state must facilitate contact and share parenting arrangements unless there is a compelling reason not to do so for the interest of the child. For example, if there is a danger of a risk of harm to the child. This article does not only apply when parents live together, but also when children live apart from the parent. What I can say about these cases in general is that they display a rather consistent approach by the court, namely that the domestic authorities must act in due diligence required of them to discharge their positive obligations under Article 8 of the Convention to restore contacts promptly when they have been broken. On the basis of insufficient or lack of effective measures, the court repeatedly finds violation of Article 8. Thus, in general, the court takes a rather assertive position against what has been called parental alienation, a strategy or behavior whereby one parent intentionally displays to the child unjustified negativity aimed at the other parent with the purpose of damaging the child's relationship with the other parent and often to turn the child's emotions against it. A famous case in this regard is a case of Keegan versus Iceland, and this is a landmark case in the sense that the court held that the family life continues to exist after parental separation. This means that the ties between child and the father that has left the home or even has never lived there is seen as a family tie that warrants protection under Article 8. And this is an important precondition for everything else in relation to these issues. There are more cases, and I can tell you about a very recent case against Poland. The judgment was actually handed down last October, so it is quite fresh. This is an interesting story. The applicant maintained relationship with a married woman from 2004 to 2009, during which 2 children were born, 2005 and 2007. Based on the legal presumption, the mother's husband was registered as the children's father, the pater est principle. So it was not the biological father that was registered as the father of the children. The applicant requested that public prosecutor institute proceedings to challenge the presumption of paternity, as he himself lacked standing to do so directly. Although proceedings were eventually instituted in January 2013, and take note of the time factor in this case, at this point the children were 8 and 6 years old. The court refused to allow the applicant, the biological father, to intervene as a third party in the proceedings. So basically, even though there was no disagreement that he was the biological father, he was kept out of the proceedings. The proceedings were then characterized by an extreme slowness. It took 6 years to appoint a guardian for the children and 10 years to hear the first witness. Crucially, no decision on the merits was reached until both children had reached majority. So they were not children anymore, finally when the result came. Resulting in the applicant being definitively deprived of the possibility of having his paternity recognized due to limitation periods. In parallel, the applicant sought the regulation of contact with the children, despite a final order in 2014 granting him monthly contact. The mother and her husband refused to comply. Enforcement proceedings proved ineffective, as it took 4 years merely to threaten financial penalties, and no single penalty could be imposed for more than 3 years. The court found a violation of Article 8 of the Convention, emphasizing that the authorities failed to exercise the exceptional diligence required in cases concerning parent-child relationships, allowing the passage of time to determine the matter de facto, and awarding the applicant €20,000 for non-pecuniary damage. The judgment states, inter alia, the domestic court effectively deprived the applicant of the right to have his paternity of the children established, having not only allowed the passage of time to determine the matter de facto, but having also allowed his further attempts to that effect to become time-barred. So basically, the behavior, so to speak, of the authorities led to his claims to be time-barred, because when the final result came, the children, they were already adults under the law. Article 14 of the Convention is about the prohibition of discrimination, where one parent is systematically disadvantaged in custody or visitation decisions. Also, when parenthood is established, this can happen on different levels. Discriminatory treatment in parental responsibility cases could constitute a violation when combined with other articles, and in particular Article 8 of the Convention. There is a relatively recent case that throws light on these Article 14 issues, and that is Paparrigopoulos versus Greece. And this is a judgment from 2022, June 2022. The applicant is a father of a child born out of wedlock and was unable to exercise parental responsibility without the mother's consent, in spite of fatherhood being established by a DNA test. In 2007, the mother of the child instituted on her own paternity proceedings, alleging that the applicant was the father of her daughter. who had been born in 2002. In 2008, a DNA test ordered by the Court of First Instance established that the applicant was indeed the biological father of the child. By a formal written notice, the applicant requested the mother's attendance before a notary to execute an acknowledgement of paternity of the child, but the mother did not attend. The national courts rejected the applicant's request to make a voluntary acknowledgement of the paternity of his daughter before a notary. In 2016, then the girl is already 14 years old, the Court of Cassation held that as long as the child's mother was alive and had legal capacity, the father's only recourse, if she withheld consent, was to apply for a judicial determination of paternity. The court found that the domestic law subjected the unmarried father of a child born out of wedlock to a difference in treatment in relation to the child's mother or a married or divorced father. We are talking about a different treatment compared to the mother and a married or divorced father on the other hand, and the applicant in this case. In particular, Article 1515 of this Greek Civil Code provided that in case of judicial determination of paternity, an agreement between the parents was required in order for an unmarried father to exercise parental responsibility. The court could decide otherwise at the father's instance where the interest of the child so required, but only if the mother no longer had parental responsibility or was unable to exercise it for legal or practical reasons, or if an agreement had been reached between the parents. The court further found that in the present case, once a DNA test had established the fatherhood of the child, the applicant had sought to have his paternity acknowledged. Domestic law, however, would not have allowed him to exercise parental responsibility, even where doing so would have been in the child's best interest. Nor had it been possible for him to obtain a court order to overcome the mother's withholding of consent to share parental responsibility, even though she had not denied his fatherhood. And then there's an interesting part in the judgment where the court said that it was not persuaded by the government submissions that a mother-child relationship was different to the father-child relationship. Although obviously that might be true in some cases, the arrangement could not be used here to deprive the applicant automatically of the exercise of parental responsibility. I understand that changes have been made to the Greek legislation that would have led to a different outcome now if it was proceeded before the Greek authorities and courts. While having regard to the authorities' wide margin of appreciation in matters of parental responsibility, the court reiterated its previous finding that the point of departure in majority of member states seems to be that decisions as to parental responsibility were to be based on the child's best interest and had to be subject to scrutiny by the domestic courts in the event of conflict between parents. The government had not adequately explained why it had been necessary at the material time for domestic law to prescribe such a difference in treatment between fathers and mothers of children born out of wedlock and of children born in wedlock. As regards the discrimination alleged, there was no reasonable relationship or proportionality between the preclusion of the applicant's exercise of parental responsibility and the aim pursued, which had been to protect best interests of children born out of wedlock. And in addition, the court also held unanimously that there had been a violation of Article 8 due to the failure to respect positive obligations to exercise exceptional diligence in such cases, which meant that a time elapsed 9 years and 4 months at the levels of 3 jurisdictions and this was not regarded as reasonable. So here again, the time element is of great importance. This case and some earlier cases alike show that depriving a father not in relationship with the mother of contacts may give rise to violation being found of Article 18. This is, in my humble view, something worthwhile exploring further and possibly to detect systematic problem in certain countries where biological fathers, not in relationship with the mother, are excluded from all contacts with their children, either by law or lack of enforcement. Article 6 guarantees fair trial and is applicable in its civil limb and judicial proceedings concerning parental responsibility, including disputes over custody, visitation, and contacts. It ensures that parents have an effective opportunity to present their case before an independent, impartial court and having them adequately considered by the courts. It is also relevant in criminal proceedings involving children, either as the accused or a victim. Article 6 secures the right to court proceedings and that the child's views must be considered according to age and maturity. Namely, the authorities must provide procedures enabling the children's participation in the process, as well as procedures for parents to seek their rights to custody, contacts, visitations, etc. Time is of essential importance, as we can see from the Polish case that I talked about earlier, and more cases. Here are two cases being referred to support this. In Hokkanen against Finland, where failure to enforce contact rights quickly and effectively breached Article 8 and implicated Article 6 fairness concerns as well, due to the time that elapsed. And one may also mention NT versus Georgia, where a lack of effective legal representation of a child violated Article 6. There are many such cases, and it is well established that respecting Article 6 obligations is of important in these kind of cases. Okay, so now let's see what sort of principles that can be extracted from this jurisprudence that I have been discussing. And these are the points that I would like to emphasize. The court does not mandate shared parenting. It rather facilitates that contact rights are effectively enforced to facilitate both parents' involvement in the upbringing of the child. National courts retain discretion guided primarily by the best interests of the child. This means that the child's best interests always come first. Decisions must be child-centered rather than parent-centered. Article 8 requires states to facilitate contact with non-resident parents, and unjustified denial or restriction of access may constitute a violation if it is not enforced. While the court often defers to national authorities, it supervises proportionality and fairness at the end of the day. The court is ready to apply Article 14 in particular to avoid fathers being discriminated against, in particular fathers who do not any longer live with the mother or have never lived with her, regardless of whether this was marriage or cohabitation. Parents must have an effective opportunity to present their case before an independent court. This is Article 6. Judicial delays or failure to enforce visitation orders, contact orders, can violate Article 8. The court recognizes various forms of parental responsibility, including joint custody, shared parenting, or structured visitation, depending on the child's needs. Which way to go from a legal point of view is for the states to decide. What matters is that there is an option for visitation, contacts, and these rights are being effectively enforced. Final remarks. The court's case law concerning children's rights reflects an expanding framework, especially in disputes involving shared parenting, post-separation contact, and parental responsibilities. Some might claim it is not entirely consistent. It is argued that the court has repeatedly affirmed that children are independent right holders under Article 6 and Article 8, regardless of the rights of the parents, emphasizing procedural fairness, timely decision-making, and the need for authorities to act in the child's best interests. Some would claim, yet in practice, its reasoning often priorities maintaining family unity and facilitating parental contact, sometimes at the expense of the child's expressed wishes or safety. As regards shared parenting disputes, the court has consistently stressed the importance of both parents' involvement in a child's life. It has held that states must take all reasonable measures to enforce contact orders and support ongoing relationship, criticizing delays, administrative inertia, or inadequate social service intervention. This reflects the court's broader commitment to co-parenting and its reluctance to endorse arrangements that marginalize one parent, usually the father. Thank you very much.